Hello, everyone, and welcome to our webinar, Navigating IDEA and FERPA to Protect Privacy in Today's Early Childhood World. My name is Sharon Walsh, and I have the pleasure of representing both the DaSy Center, which is the Center for IDEA Early Childhood Data Systems, and the Early Childhood Technical Assistance TA Center on this call. We are both OSEP-funded TA centers, and I'll be joined by some colleagues in a minute. You can see we have quite a few logos on the slide. I'm very pleased to be here, and I want to welcome you all and let you know again, if you didn't hear, we're recording the session. We'll turn off the recorder at some point. We're going to leave everyone on mute because the size of the webinar, we don't want to have any extra noise to distract you. So we'll all stay on mute. As you're listening over the next hour, we really encourage you to please jot your questions in the chat or just jot them down near you and we can put them in the chat later. We're going to have plenty of time for Q&A after the presentation, but we'd like to keep the time, make sure we stay to our time. You'll get the slides later, and we're going to be rolling out some new resources today too. So again, we're really pleased you're here. We have about close to 80 people on now, and we know by the registration that we have quite a few more coming. So again, welcome, welcome. I think that was probably all the housekeeping I want to do. So why don't we go to the next slide? Thanks, Ross. Just want to run through the objectives for you, and then I'm going to introduce the speakers, and we'll find out a little bit more about you before we begin with our content. We have three outcomes for today's webinar, and you will get an evaluation after the webinar is over, and you know how much we appreciate you completing those. You will have an increased understanding of IDEA and FERPA as these relate to data privacy. You'll have the opportunity to discuss issues related not only to the COVID-19 impact on services, but data sharing across programs. And third, you'll be identifying and obtaining resources related to privacy and data sharing. The numbers are still growing in the chat, so that's terrific. Thank you. I want to introduce our panel. We are so fortunate to have the folks who are willing to join us today. It's been a while since we've had one of these privacy confidentiality webinars, and really looking forward to this. We have two speakers from the U.S. Department of Education who I know you all know, but I want to make sure, refresh your memories. The first speaker will be Surprenant. She's the Senior Counsel from the Office of General Counsel in the department. And Frank Miller, who's the Deputy Director of the Student Privacy Policy Office in the department. And they will be joined as well by Ross Lemke, a great partner of DaSy and ECTA's. We've all worked together for a long time. And Ross is the director of the Privacy Technical Assistance Center, or as we call it, PTAC. And again, I'm Sharon Walsh with DaSy and ECTA. Let's find a little bit about you. This will help our speakers and it will help us as we go. So we have two quick polling questions. My colleague Rachel is going to bring them up, but not quite yet. First polling question, and you have a lot of choices here. So let me just walk you through it quickly. Select the option that best describes your primary role. And so you can see we have 7 choices, including other. Feel free to select other if you want. And we start at the top with Part C coordinator, data manager, then Part B preschool coordinator or data manager, and then it continues on down with other state staff, parents or family members, and any TA providers that are on the call. So Rachel, how about if you bring up the poll and we'll see who's here. So look, oh, we've got quite a spread of folks. Very good. So we've got a lot of folks who are either Part C coordinators or data managers. We have some other Part C state staff. We have other staff in general from other offices, including certainly the Part B office, family members, and quite a few national and state TA providers. Welcome. That's a great spread of folks that will really help with our conversation. Now let's get a little bit of an idea about your familiarity with the topic. So we've got a second poll question. And in this question, we're going to ask you how familiar you are with the IDEA and FERPA requirements. And you've got 4 choices, leading off with you're very familiar with them. You have knowledge of them, but you really would like a refresher. You've got the basics, but you'd really like more information. Or you're not familiar and you're just looking forward to it, and that's why you're here. Rachel, how about if we pull up that poll? Great. So the majority of the people would say they've got the basics but need more information, followed by people who would like a refresher. A few people who are familiar with the requirements probably should be up here on the panel with us, and a couple of folks who really look forward to learning. Some folks who look forward to learning more about these requirements. Again, terrific spread. All questions are good questions. Keep jotting them down as you listen, and feel free to throw them in the chat as we speak, or wait and put them up a little bit later. We still have folks joining us, which is great. But we are going to go ahead. I'd like to go to the next slide and just quickly run through the agenda. I don't want to take any more time with our pre-work here. We're going to start off with highlighting 2 data sharing resources. I'm going to walk you through or show you a checklist that we're highlighting today, a brand new one. And then Kala's going to share with us a really exciting template that the department developed with CDC. Then we're going to have a good chunk of the time, going through an overview of the privacy requirements and the privacy themes under IDEA and FERPA. Then after that, we'll do some more practical work, kind of applying these privacy laws to some scenarios. And these scenarios will not surprise you at all. I expect we'll see lots of nodding in the camera when they come up, because they're ones that we all hear and talk about all the time. And once that's done, we'll move into some resource sharing and certainly save a good, hopefully 15, 20 minutes to do some good Q&A, and we'll turn off the recorder at that time. So with that said, I'm going to ask us to go to the next slide and let's start highlighting these 2 resources for you. I'm going to mention the first one, which is the Party EDI New Data Sharing Agreement Checklist. And I want to tell you a little bit about this, and then we'll go to the next one Kala will show you. So I've got 2 slides here to show you on the checklist. And Rachel, I know, is going to be putting the link right in the chat for you, so you have the document. There's a link to it on the ECTA website and a link to get it on the DaSy website. And it probably, as we speak or momentarily, will be on the website of the 3rd partner in this document development, which was NCHAM, the National Center for Hearing Assessment and Management at Utah State University. This document is really kind of an exciting in development. And I think you'll appreciate it for a lot of reasons, but particularly because it was developed by state folks. There's a National EDI Outcomes Committee that's comprised of state Part C individuals and EDI representatives. It's got federal staff from the CDC, from HRSA out of HHS, and from the OSAP office out of education. It's got TA representatives. It's got family organizations, lots of folks. And it's been meeting for, I'd say now, well over 10 years with TA support. And these folks together work toward making more collaboration between EDI and Part C across the country. They have a particular emphasis on data sharing, but not exclusively data sharing. So there's lots of good collaborative strategies shared, documents developed, webinars offered. And so I think you'll find these materials really grounded in the kind of things that you need and want to hear. The publishers of the document are DaSy, ECTA, and NCHAM, and it's really designed as a resource for state staff as they're beginning to or in the middle of developing data sharing agreements. If you've done one before, and there are quite a few states who already have working data sharing agreements across EDI and Part C, you know that they're best done if they're benefit both programs. You know they take time, effort, lots of collaborative partnership work goes into making them, to developing them. You need to come to agreement on the elements you'll share and how you're going to protect the data, the privacy of the data, the access. And so there's a lot of work and it takes a while. So hopefully this checklist will be a good resource. If we go to the second slide, just a couple more points about it. The good news, extra good news, is that we were able to get this reviewed and we made appropriate revisions from the federal office. Folks on this call, thank you very much. And so we know it's consistent with IDEA and FERPA. And you'll notice when you open it up that while it is formatted as a checklist, it includes both essential components, things that you really have to have through the regulations, and then things that are suggested additions. And those all came from the state's this national work group. So you can get the benefit of learning how other people approach these agreements. So we would encourage anyone who wants to use it to look at it in terms of your state context, what your state specific circumstances are, what the EDI program and the Part C program need, where they're housed, and particularly any additional state privacy requirements, which you very well may have over and above the federal requirements. And on that same note, you're encouraged, of course, always, and that's included in the document, to get guidance and check with your legal counsel at the state level. So I'm going to pause there, and the link I'm sure is in the chat. And what I'm going to do now is ask Kala if she'd be willing to share the template that we want you to really take a close look at. Kala?
Thanks, Sharon. We are excited to see the DaSy and CHAM and ECTA checklist that's finally out. We had a chance to look at it, and a lot of work has gone into it. So thank you for sharing that, Sharon. What you're seeing on the screen now is the product of also a couple of years of work. Back in 2020, when I was acting director of the Student Privacy Policy Office, we were approached by the Centers for Disease Control's Autism Survey Program. And that surveillance program, which is known as the ADDM network, works with public health agencies across approximately a dozen or so states and sites to collect data on the prevalence rates of children with autism and other outcome-related information for children with autism. Fast forward, we were in the middle of the pandemic. We really couldn't pursue it at the time, but we had separately received, our Office of Special Education Programs, OSEP, had received multiple inquiries from IDEA programs, particularly Part C, but also from 619 and Part B, asking about how they might be able to work with the autism programs because they had been approached about sharing data. We began by developing some legal options, which we'll talk about today, in how data can be shared under both IDEA and FERPA. But more importantly, we worked with over half a dozen states to identify what their concerns were about sharing data, what outcome-related information they would be looking for to help benefit children with disabilities who are served under IDEA, and how could we do this. So while I'm sharing a little sort of snippet of the template right in the slide, we are going to talk a little bit later about how one can do this. And it's not a simple process. It's not just, oh, I'm going to fill out a form and now all of a sudden we're going to be able to share data. This requires not only buy-in, but careful review by both programs that will be sharing any data, and to determine what is the specific purpose, what is the benefit, and how can it be done so that it is truly an evaluation of the IDEA program and outcome-related information. So I've shared this information. This template is already on CDC's website. We, the Department of Ed, are working with our partners and TA providers, including folks here on the call, PTAC, DaSy, ECTA, and other TA providers, to get this on our websites as well. But for now, you can find this link in the CDC Autism Network. Thank you, Rachel, for putting that into the chat. And CDC really acknowledged the efforts of the Office of Special Education Programs, our Office of General Counsel, and our OSER's office in working with the CDC and their General Counsel to come up with this data agreeing format. So let's go to the next slide, Sharon. But we're very excited. We have two great new resources. Ross, do you want to walk us through our next stage?
Yeah, absolutely. So now is the part of the presentation where we're going to kind of take a step back from these new resources and level set by going over an overview of privacy under both IDEA and FERPA. And then we're going to talk a little bit about some common themes that we see across both laws. So as we start to think about, I would say, FERPA and IDA, obviously there's sort of the tactical level of privacy where you have service providers, state staff, people that are providing services that are interacting with children and or students on a day-to-day basis. And then there's this strategic level privacy where we're talking about data that is being held by agencies. And one of the things that is commonly done with that data is that it's being looked at, reviewed, analyzed, and at sometimes it needs to be shared. So before you share data, however, it does kind of require an understanding of the requirements under both IDA and FERPA. So Kyle, I was hoping you could kind of walk us through a little bit of some of the requirements under the Individuals with Disabilities Education Act.
Thanks, Ross. Glad to do so. And I think we'll, partner with my good friend, Frank Miller. For those of you who've seen us do presentations in person, you know that we're quite close friends and colleagues. And we have really enjoyed working together to try to make it easier for all of you as you serve children with disabilities under IDA to figure out what are the appropriate ways to share both information, personally identifiable information, and data. So, of course, under IDEA, parents of children who are referred to IDA have the right to access the information in their child's records. What is protected is the personally identifiable information, or PII, which is a term under IDA and FERPA. They also have the right to seek to have those records amended. And the most important right, I think, that most parents would identify is that right to consent to the disclosure of PII, or personally identifiable information, in which we consider that as a fundamental right of privacy in many of our statutory frameworks. IDEA includes protections beyond FERPA. So it's really critical. If you get nothing out of this, just what's in bold here, just remember this, right? The lesson learned, when you're reading IDEA and FERPA together, always start with the IDEA first. We often think of FERPA as the privacy law, and it is. It's a very important privacy law that identifies exceptions, but it is for children with disabilities who are referred to IDEA. You really have to start by reading the IDEA provisions first. And Frank, you want to talk a little bit about the comparable provisions under FERPA?
Sure, Carla, thank you so much. Glad to be part of today's presentation. So FERPA, Family Educational Rights and Privacy Act, written in 1974, a long time ago, basically to afford parents and eligible students some certain rights to access education records that the schools maintain on behalf of either the student or the parent's child who's in attendance at the institution. Seek to have certain education records amended, things that are inaccurate or incorrectly recorded. You can request to have those records amended. The big thing is to consent to the disclosure of a term we use, PII, or personally identifiable information. So, prior to 74, parents didn't really know what schools maintained on their kids. They didn't really have an understanding of how they could access it or consent to its use. So when that was passed, and it's been amended about 11, 12 times since then, to basically afford parents those rights. And you're going to see a lot of parallels as we go through the presentation on some things that are in IDA that reference FERPA directly, and there's just some general parallels. One of the things we talk a lot about is FERPA protecting education records, and the litmus test, or the question we've been trying to answer here is, what are education records? And those are those records that are directly related to the student and maintained by an educational agency or institution. Colin and I usually have a little competition to see who can say it as the most times, so I'm going to use this as a chance to get my first one in. But as alluded to on the previous slide, when you're looking at IDA and FERPA together, always start with IDA, because there are going to be certain things that if you look under the FERPA lens, you're going to want to pull your hair out, and it's going to cause you a lot of angst and grief. But if you start under that IDA first lens, it'll make things a lot more clear and easier to navigate through. So that's my first chance to get that one in. And I think we're going to kick it over to the next slide now.
Well, yeah, so Kala and Frank, I mean, the both of these laws, who do they apply to?
So that's a good question. It's different, right? IDA applies to participating agencies, and specifically the IDA confidentiality provisions must be enforced by and implemented by participating agencies. The definition of a participating agency under IDA is different for Part B and 619 than it is under Part C. Part C is very specific and excludes individuals or entities who I would consider as purely a primary referral source, like the doctor who refers the child to the Part C program, or in the instance that Sharon was talking about with the example earlier, where an EDI program is referring a child who has hearing impairments to the Part C program. It also excludes from a participating agency an agency that is purely a payer of the service. For example, Medicaid can pay for Part C services. It may be in a different agency. For example, you have an ed lead or an SEA, state educational agency, that's serving as the lead agency under Part C. Medicaid is under a different agency. Medicaid would not be a participating agency if its only purpose is to fund or pay for the Part C services. The definition of participating agency, though, can get a little murky under that umbrella of programs that are considered part of the Part C network in a state, because there are times when, for example, an EDI program may not just be referring a child, but may also do an audiology eval or help coordinate other services. So sometimes that definition of what is a participating agency becomes important, both under Part C and under Part B. So let's hang on to that definition, but that is a critical difference in terms of who must comply with the privacy provisions. And Frank, FERPA is definitely different in this regard.
Thanks, Kala. Yeah, FERPA is a little, I was going to say more straightforward in that FERPA applies to any educational agency or institution that receives funds coming through the Secretary under the control of the Secretary of Education. We often get questions about, well, what if we participate with free and reduced lunch? That's actually a program operated under the USDA, not the U.S. Department of Education. So how does that come into play in like an early childhood setting if you have a child who is getting 619 services in an early childhood setting? What we typically say is a couple of things just to clarify. If a student is getting a service in a school, so FERPA applies to those institutions that get U.S. Department of Ed funds. Often excluded from that, especially in the K-12 space, are private and faith-based schools. They don't get U.S. Department of Ed funds, so they're exempt from having to comply with FERPA. I don't know if anybody's in my home state, but I know some state laws may encourage our early childhood programs or our private schools to follow FERPA-like requirements. But FERPA, as far as our office and our oversight at the U.S. Department of Education, is only if they get U.S. Department of Education funds. Not so much in this. Not so much in this space, but in the post-secondary, most of our universities all participate in federal student aid. So almost every university, I think there is one, the last time I checked, that did not participate in federal student aid, has to comply with FERPA.
And I just wanted to reiterate that even though a state agency will provide other funds to schools and may have, in an LEA setting, may place a child in a private school, if that child is served under IDA, regardless of whether federal funds are received, IDA privacy provisions will still apply. So that's an instance where IDEA applies, but FERPA does not, and they do contain very comparable privacy provisions. So I just wanted to reiterate that.
Yeah, thank you, Kyle. That's a great point. And the other caveat I want to add to that is if it is a private early childhood setting that has a child in the school getting, say, special ed IEP services, that wouldn't mean the entire school has to comply with FERPA. But as Kyle said, there would be certain protections of those records under IDEA and FERPA.
Well, thank you, both of you. That's very helpful. So I've noticed that there's a bit of a timely, time component to this. So could you maybe talk a little bit about when these rights kick in?
Sure, we clarified when we added the IDA privacy provisions to the Part C regulations in 2011 that the Part C privacy provisions apply from that point in time when a child is referred to IDEA. We don't have that similar language in our Part B privacy regulations, but that is in fact the point in time when IDA, both the privacy provisions under Part C and under Part B, apply. One of the reasons we added that provision was that we saw so many referrals, including a lot of not just personally identifiable information, such as contact information, name, date of birth, address, but in 2004, we had CAPTA amended to include the requirement that there be referral of children with substantiated cases of abuse and neglect. We had medical records and HIPAA privacy rules. And so we wanted to be clear that upon referral, even if a child is not determined eligible under IDEA, those records are protected under the privacy provisions once that information has been received in a referral. And FERPA applies slightly differently. Frank?
Yes, Kyle. So FERPA, and there's actually a small typo on this slide that we'll fix before we do the final version, but FERPA applies to when a student is in attendance at one of the schools, educational agencies, or institutions that receive Department of Education funds. So our whole premise of FERPA applies once that student is in attendance at one of those institutions. On the slide right now, we use the term eligible student, and that's kind of a separate caveat all on its own. An eligible student is when a student turns 18 and is either in attendance at a K-12 school. I don't think we have too many 18-year-olds in attendance at a preschool, but an 18-year-old that would be in attendance at a K-12 or higher ed, they have the rights from the parent transfer to them when they become quote unquote eligible students. But this slide should really say it's anytime the student is in attendance at a school, preschool, K-12, or higher ed, then the FERPA privacy provisions would apply in those situations.
So Kala and Frank, where are these laws located?
There's a lot of citations. I'm not going to read those. You have them on the PowerPoint. You don't need to take these notes. You will have access to these PowerPoints. Just know that the IDA Part B and 619 regulations were last amended. They were amended more recently than 2006, but the last major amendment occurred in 2006. And the privacy provisions didn't really change under IDA Part B. In Part C, the last major amendments to the regulations occurred in 2011. And that provision, those provisions, 303, 401 through 417 that you see up on the screen, they were added at that time. Prior to that time, we had a provision in Part C that referred you to the Part B privacy provisions and FERPA. And it was very confusing because you would have these words like student and, educational agency, institution, and you were trying to figure out like, this is for infants and toddlers. How does this work? So thankfully, we've got translation provisions in the IDA Part C regulations to to walk you through how to apply the exceptions under FERPA, and that talks about the early intervention record, not the education record. So those are when Part C and Part B regulations were last adopted. And of course, the statute was last amended in December of 2004. FERPA has been around a little longer.
I'll take us down the FERPA memory lane. So FERPA, again, first passed in 1974. It's been amended, I think I said earlier, 12, 13 times. The last time there was a lot of changes was 2011, which was similar to the Part C reg. So a good year for federal government in terms of updating some of our key regulatory provisions. We have had a couple amendments since that time in 2013, and we'll talk a little bit about it, I think, in one of the later slides, is the USA Amendment, the Uninterrupted Scholars Act, and we'll talk about that. But that was in end of 2013, President Obama signed that, and that was the last time. If anybody's seen, we do what's called a unified agenda, where we talk about proposed regulations that we're hoping to modify in the near future. I think FERPA has been on that list for the last several years, and it's again one of those things slated that at some point we hope to re-regulate on. But the last time, 2011.
So these conversations about child versus students, it seems kind of abundantly clear that words matter in these laws. So what are some of the differences between the key definitions in these laws?
I think I'll start with this one, Kala, if you don't mind, just to kind of jump in. So as Kala said earlier, FERPA, you're going to hear a lot about education records, and we define those as those records that are directly related to a student and maintained by the school, by the educational agency institution. The Part C side of things, you're going to see, as Kala said, terms like early intervention record. You're going to talk about schools versus participating agencies. And having come from the Part C world, I was a Part C data manager and part coordinator for years in my home state of Pennsylvania. It was always trying to find that translation. And in 2011, correct if I'm wrong, Kyle, I think it's 313-414B. I call it the kind of secret decoder ring for translating Part C and FERPA. So there's going to be a lot of, it's a side-by-side where it'll walk you through. So really, really helpful kind of doing that crosswalk between Part C, Part B, 619, and kind of the FERPA landscape. Again, in FERPA, we talk a lot about personally identifiable information. And these are those kind of common things: name, social security number, school ID, address, email address. Those things that, if you come from a data perspective, almost have like a one-to-one correlation. So it's things that you can track back to a student, kind of the common themes, and that's what really FERPA is intended to protect. Personally identifiable information contained or from students' education records have some protections under FERPA. And I think Kyle is going to talk a little bit about some of the other aspects of FERPA 98 in terms of definitions of parent and child and student. Kyle?
Thanks, Frank. So as Frank mentioned, there are some terms that are similar under IDA and FERPA. Education record is one where the definition under Part B and FERPA is the same. Early intervention record is a little different. And whereas FERPA focuses on records that are maintained by an educational agency or institution, as Frank mentioned, IDA uses the term collected, used, or maintained. So it's broader. And you have to remember that IDA is broader in terms of the records that are covered. Two other areas where IDA differs is our definition of parent. We have a much more granular definition of parent, and we have a hierarchy. So we have in our regulations a definition of parent that includes both the biological or adoptive parent, a foster parent, and then others with whom the child might live. For example, a step-parent or grandparent. We also have a hierarchy provision that says when multiple people are seeking to act as the parent, in general, the biological or adoptive parent's rights are honored first, unless there's been some sort of legal termination of those rights. In addition, under IDEA, we have references to court orders and the significance of those for the definition of parent. We'll talk about a scenario later where we get into the definition of parent, but I wanted to highlight that the IDA definition of parent is much more specific than FERPA. With respect to who we're talking about, whose rights, we're talking about the rights, the privacy rights of the children in the program. Children with disabilities is a term of art under IDA. Infants and toddlers with disabilities is a term of art under IDA Part C. And FERPA really talks about students. So there is a difference in whose rights are impacted. It's very critical, therefore. I'll let Frank say it this time. He's going to get an edge on me.
Mm-hmm.
What I think you were alluding to is the fact that if we are reading IDA and FERPA together, we should probably always start with IDA, correct?
Yeah, I think that's what I was saying. You can tell we have some kind of bet going on this, but we'll discuss that after the call today.
So between these laws, are there any other differences that we should be aware of?
Yeah, IDA incorporates FERPA's privacy protections and exceptions, but IDA has additional exceptions, both under Part B and under Part C, beyond FERPA. For example, we have that early childhood transition opt-out. complicated piece that we're going to talk about in our scenario later. So always start with IDA first, because there are additional protections, there are additional requirements, and there are additional exceptions beyond FERPA. I am not going to let you say it this time, Frank.
So I do think that, looking at both of those laws reference something called consent. Why does that matter as far as FERPA and IDA go?
Yeah, so consent is really important. There's some things that are common between IDA and FERPA. And I think, Frank, maybe you should talk about that, because those are really true for both laws, right?
Yeah, Colin, let me start off, and then I'll turn it over to you. You can talk about some of the specific aspects under IDEA. So what does consent mean? I think both IDEA and FERPA have provisions where a parent provides prior written consent before the disclosure of PII or education records. So basically, a parent has the ability to control some of those disclosures of their child's records. We don't get so much into it in this presentation, but there are some exceptions to where written consent. And I think pretty much all your consents have some basic components. What records are going to be disclosed? To whom? What's the purpose of that? The parties, so like the parties who's going to get it. So basically, you're giving consent to say, hey, I'm okay with my students' records being disclosed with this individual, this party for a specific purpose. Some of them will have different things on how long the consent's valid and how you can revocate it. But in general, they have, under both IDA and FERPA, those are the kind of common core elements for those prior written consents prior to the disclosure of information. I think, Kala, you want to talk a little bit more about the IDA specifics?
Sure, Frank. But before I do, I just wanted to mention both under IDA and FERPA, as we've discovered in the pandemic, we have to get that consent in writing, right? And we have had now with the pandemic, the ability to ensure, of course, that the signature is authenticated, but you have this opportunity now to get electronic signatures. So, but it must be in writing, right? It can be electronic, but it can't be oral. So that's something I wanted to highlight. And then IDA, in addition to saying it's got to be prior written parental consent, it must be informed. What does that mean? So what you're looking at carefully then is, what does the document itself say in terms of informing parents of their rights and to what it is they're consenting? So often you'll see a lot more language in an explanation around IDA consent forms than you might under FERPA. Ideally, they would be under both, but that requirement is clear under IDA that it must be informed consent. And that also affects, for example, language and translation. The second concept under IDEA that is important to remember for consent, particularly, is that when you need prior written parental consent, it's not just for the privacy that you're going to need it. You're going to need it for other areas under IDEA: consent to evaluate, consent for the provision of services, consent to use insurance. And so it's really important when you're thinking about planning your program, as you look at the current thinking on how to communicate with patients, clients, customers, children, parents, that you're managing from the outside in, that you're looking at not having parents come back and sign multiple forms. So if you're getting consent up front for disclosing personally identifiable information, sharing data or sharing information with others, that you're also getting whatever other consent you need at that time, right? You're trying to do this without creating as much burden for families. So remember that consent is important to obtain for privacy purposes, and where possible, if you can combine it with other junctures that make sense for families and children and parents, that you are doing that as well. Next slide, please.
So we've talked about how the laws are different. Kala, Frank, how are there areas where they're similar?
Yeah, Ross, I'll jump in. I think there's some common rights that are consistent more so with both under IDA and FERPA. So parents have some basic inherent rights. The right to inspect and review records. I think in an earlier slide, we talked about accessing records. It's basically the same thing, that as a parent, you have the right to inspect and review the education records maintained on your child. Each school has some different provisions how you do that. You may have to submit a written request to a certain individual, but that's the basic premise. You have that right to inspect and review. What does that mean in terms of copies? We often get a lot of questions with that. And typically a school can provide the ability to an inspect review records. It's an on-site right. So you can come on site and inspect and review records. With COVID, we saw a lot of schools were not having on campus, everything was online. So a lot of schools will give that ability to inspect and review records through some kind of online portal. Power School, there's a host of them out there where a parent can actually log in and sit at home and review and inspect and review their child's education records. We do have some caveats under FERPA for copies of records. So if a parent's right to inspect and review is impeded because they live in another state, or they live outside, we usually say commuting distance, there may be situations where under FERPA, the school would have to give the parent a copy of the records. They usually can charge a fee for that, for the copying, not for the retrieval. I think under IDA, from my times in that world, there are certain things that parents are entitled to: a copy of an evaluation report, a copy of an IEP or an IFSP. So there are some things where both laws have provisions for copies. Sometimes it's free under an IDA. Other times, there may be a nominal cost under like FERPA, as long as it doesn't inhibit the parent's ability to review those records. Both laws also have provisions for if I'm reviewing my child's records and I find things that are inaccurate or misleading, I can request that those things be corrected. I have to always add the caveat, and we kind of have this in the next bullet, that doesn't include substantive decisions. So FERPA and has a right to request the amendment of a record. You can't use that to say challenge a student's grade. Most schools have some kind of mechanism for how you can, grieve a grade or that. But FERPA's amendment provisions are really about those non-substantive pieces that there's something inaccurately recorded. We also say in terms of building an IEP or part of the evaluation report conclusions, those are things that are typically not, you can't request to amend them under FERPA, but we know IDA has very specific procedural safeguards. That's how a parent could exercise their rights to challenge or question the content of, say, an IEP or an evaluation report. Both laws have provisions where if I'm a parent and I request the correction or amendment of my student's record, school, either through some kind of unbiased individual, reviews that and decides, we don't think that it is inaccurate, that we don't need to amend that record. The parent has an opportunity to include a statement in the student's education records, kind of explaining their side of things, that's maintained for as long as the record is maintained. So here's some common rights that are consistent across both IDA and FERPA that kind of give some basic rights to parents.
Okay, so setting these commonalities aside for a moment, are there other areas where they are different that we haven't talked about yet?
Yeah, I think I'll start with this one just because I have a good vibe going, and then I'll turn it over to Kala to kind of pick up some things. But I think both things have documentation or access logs, right? Record keeping requirements under FERPA, we call it recordation, but keeping records of those times where records are shared or accessed by other individuals. I think if any of we have some state individuals on the call, when you go to do your on-site monitoring, you usually have to sign that access log in the front of the student or the child's records to say, hey, I was in here and I did an audit. So both of them have some common record keeping requirements in terms of requests for access, disclosures, and those kinds of pieces. I think, Kala, do you want to talk a little bit from like an IDA perspective?
Sure, Frank. So IDA has a couple of extra provisions in the space around records. First, this is really important because we don't have in the privacy space in education information security laws similar to, for example, HIPAA or GLBA, which is the I can't even say it, GLBA. But information security isn't something that we focus on because we don't have a specific standard that's used that applies from a federal perspective to education records. We do have a privacy standard, and similar to many information security laws, there is a requirement under IDEA that each participating agency designate a specific individual, one individual, who is responsible for ensuring the confidentiality of PII. As we see an increase in ransomware attacks in school districts, as we see information security and data breaches becoming more prevalent, it is really critical that people focus on this provision, because we have found that a lot of state agencies and local educational agencies and EIS providers are not familiar with this IDA requirement. The purpose of designating an individual specifically as a point of contact in your EIS provider, your LEA, your SEA, your state lead agency, is to ensure that that individual understands what the training requirements are, if there is a data breach, what the responsibilities are, and to ensure that the privacy provisions of IDA and if FERPA applies, FERPA are protected for the students and children in your participating agency. So I'm spending a little time highlighting this now in our briefings, and are going to ask our TA providers to do the same, because I think this is going to be an area where record retention policies and identifying specific individuals is going to become increasingly important. In addition, I wanted to mention that under IDEA, we have record retention provisions and requirements that specific records be destroyed if the parents so request after the records have been maintained per a records retention schedule. This begs the question, do you have a records retention schedule for your participating agency? And you might have one that applies overall to your state lead agency or your SEA, but you need to look at it specifically in the context of IDEA and the IDA requirements to ensure that you're complying with those provisions that respect that parent's rights to request the destruction of record, as well as what can be maintained as a permanent record beyond even a parent's request to destroy. So this is really important information to focus on, and we are encouraging agencies and providers to reach out to TA providers if they need help developing record retention policies and schedules. Factoring, of course, information and advice from your legal counsel on statute of limitations and other appropriate timelines. So record retention policies, if you don't know what they are, go find out or find somebody who does. If you don't know who your point of contact is for your participating agency, same question, go find out or designate one. But if you have any questions about this, please reach out to us at OSEP and at the Department of Education. Next slide, please.
So Frank and Kala, both IDA and FERPA have different types of notices. Can you tell me what's different about them?
Paula,
Sure.
do you want to handle this one?
Sure. IDA and FERPA both require an annual notice to parents about the privacy provisions. And I think most of us are familiar with those notice requirements under IDA as well as under FERPA. But we also have a requirement under IDA for other notices, which include procedural safeguards notices, notice of an action that we're about to take, whether that's an evaluation or scheduling a meeting for an IEP or an IFSP. So notice requirements are really important because that's how parents are informed of their rights. It's also how you can point back to your notice if there are exceptions that you're exercising that are consistent with the IDA and FERPA requirements, because we are going to talk later about when can you share information, PII, or data that includes PII without parental consent. So I think the notice piece is going to be really critical, and ensuring that your notice is updated periodically and reviewed is really important. Next slide.
So, obviously, it's not a perfect world. Sometimes mistakes are made. Sometimes there's a problem. How does IDA and FERPA handle problems when they arise?
So there are dispute resolution options under IDA and under FERPA. Obviously, you're all familiar with IDA's three, mandated dispute resolution mechanisms. The first being state complaints, the second being mediation, and the third being due process hearing requests. Those are all available also for disputes regarding privacy. And some states will use that due process hearing as the mechanism for a request for a hearing when, amendment of records are being sought and there's a disagreement about what that record should read. But IDA, right, the focus there is that the state agency, whether that's the state educational agency under Part B or the state lead agency under Part C, that is the agency that's responsible for ensuring, under its general supervision authority, that all three dispute resolution mechanisms are available. Some states have added additional procedures such as resolution sessions, facilitated IEP or IFSP meetings. Those are all available at the state's option as long as they do not delay the right of the parent or the child or the student to go ahead and use the three mandated dispute resolution provisions that are part of IDEA. FERPA has a different resolution process. Frank?
Thanks, Kala. Yeah, FERPA actually has provisions where a parent or an eligible student can file a complaint directly with our office, the Student Privacy Policy Office. We have a link to our website where a parent can file a complaint. It has some background information on our process and procedures, but that's where we differ a little bit, where IDA is kind of more administered, what we say at the state level, where the state affords all those options. We have, the parent has the ability to file a complaint directly with us. I can tell you as a matter of practice, we strongly encourage if a parent reaches out to us, to have they considered exercising all of their rights at the local level. Have you talked to the superintendent first? Have you worked with the state lead educational authority before contacting us? Because a lot of times some of those complaints can be better navigated and resolved at the local level rather than getting us involved. Just in case any of you happen to be working at an agency where a complaint is filed against you, just to let you know, although we have the authority, we don't come out on site. We don't have the FERPA SWAT team that shows up in your door. We do everything by desk review. We'll reach out to you. And our whole goal is to help you return to voluntary compliance. So even where we find that maybe a violation or something happened that wasn't quite right, we're going to work with you to address it and return back into voluntary compliance. So we're here to help you, not be the FERPA stick.
So Frank, Kala, I think one of the big reasons that people are on this call today is, to kind of get an understanding of data sharing. Can you talk to us a little bit how we can share data under both of these laws?
Sure, Ross. I think that I see data sharing in my head when I kind of look at a scenario. I think, well, what is happening here, right? So on a day-to-day basis, you are working directly as a service provider with the child, with the parent, or in a school setting. You're not really looking to share data beyond the immediate service delivery team. So there's really no issues there. But then something happens. You get a request from a primary referral source. And you can share data basically, or personally identifiable information in two ways, but you can share data in three ways. And I wanted to highlight that because we have received so many questions about data sharing at so many different levels that we wanted to just spend a little time in this session working with our TA partners in getting this information out. Obviously, if you have parent consent, right, that's ideal. Parents are aware of it. And if you're required to get parental consent under IDA and or FERPA, then you can share personally identifiable information provided you do it consistently with IDA and FERPA requirements. And Frank and I have talked about what those are. You have to understand, explain what the purpose is for sharing it. The PII, you have to explain to whom it's being shared, and you have to explain what records are being shared. So consent, parent consent is way one, path one. So you're in the forest, that's path one. Path two, a little more murky because technically you're not needing parental consent because they're not sharing personally identifiable information. That gets tricky. What do you mean? Well, you might be aggregating data. And you all know this because many of your agencies are responsible for reporting data under IDA Section 618 or through your state performance plan, annual performance report. And at the end of the day, you might put out a report that says X number of children, right, received services this year, right? That's your child count data. So that aggregated data, which is de-identified, and this is one where we do have some states getting into trouble. We ourselves have to be really careful because we want to make sure that when we share data in this way, that it really is anonymized, and it's difficult, right? You have to have statisticians when you're looking at data, because if that data can be combined with other public sources, and today with our open data platforms, we're very excited that we are in this open data world. We have available to us so much more data than we ever thought we would. It's overwhelming sometimes, frankly, when I look at the kind of data that's available through the census and through research organizations and through universities. And so you can figure out for, the 5 children with autism in a particular school district, and there have been articles about them in the newspaper, like it gets a little tricky. So that importance of de-identifying and aggregating data is that it really does have to be de-identified, and you should be working with your legal team, your statisticians, to understand that it's not going to be personally identifiable, that it's not going to be recognizable if a reasonable person could go out and find, equivalent data sources, connect them, and identify those individuals, because that becomes then PII. The third way, that third road in the forest, is that there are exceptions that allow you to share data without parental consent, right? They were set up. Most of our exceptions are listed under FERPA. They're adopted to apply under IDA through the IDA Part B and Part C regulations, the privacy provisions. And there are a number of exceptions. There's the directory information exception. There are a number of exceptions. They don't apply always in the same way for children with disabilities. So just remember, you have to look at what is that data being shared under IDA. Directory information is the kind of information, if you're a parent and you had a child in elementary school, they'd say, hey, we're going to, put out information, or like this class yearbook, your child's about to graduate. We're going to list, the year they graduated. That's information they can put out unless you, asked for an exception to that. But that doesn't apply the same way under IDA, because when you have a roster of kids with disabilities, you're already revealing that's a kid with a disability. So just remember that exceptions don't always apply in the same way. We don't have time today to go through all the exceptions. We could spend a week, Frank and I, teaching that course, and we would love the help of our TA providers to do that, but we don't have that time today. Instead, today, we're going to talk about one specific exception we commonly refer to as the audit or evaluation exception. And frankly, even within this exception, we're focused on the evaluation component. Frank is going to talk about it because it's the exception that's identified under FERPA, but it has been adopted under IDA in very specific circumstances. And 2 of those circumstances are the examples that Sharon and I talked about at the beginning of this call. So we're trying to do a full round circle here, if you can keep up. All right, Frank, talk about this great exception.
Sure. Let me, before I do that, let me just, because I think there used to be this term, and we're going to go into it, but like data sharing agreement, like that was the magic dust, that if you said you had a data sharing agreement, well, you could disclose anything. And that's just not true. The data sharing agreement has to be based or predicated upon one of the exceptions. And we're going to talk about audit and evaluation here. I was waiting for Kala to say at the end of her last slide, but she didn't. But this is another thing where it's really important to talk about looking at the IDA lens first before FERPA, because there are certain exceptions that just don't make sense under FERPA, but there are exchanges of information that may happen because you're all part of the same lead agency under the IDA context, that you don't have to worry about some of the FERPA exceptions. So always use that IDA lens first. And I think that makes the score 3-2 for me, getting that blurb out. But let's talk about audit evaluation exception, because this is pretty much one of the more common ones, especially if you're working for a state educational authority and you're collecting data from all your various schools across the state. You're typically under audit and evaluation. And as Kala said, there are some very specific aspects of audit and evaluation. It's you're auditing, evaluating a program, or you're enforcing or ensuring compliance with federal legal requirements related to those programs. So that's probably even more so if you're not doing a full-fledged audit or evaluation. You may be ensuring that you're complying with federal legal requirements. I think under IDA, you have to do some general supervision where you're going out and monitoring your programs to make sure they're fulfilling the requirements under IDA. You have to collect some data to do that. you're very likely doing that under audit and evaluation, but it could be done like that second prong, the enforcement or compliance with. We talked earlier about 2011, where we did some of our latest amendments to FERPA. In 2011, we added a definition of education program. And that was really to get at, we knew there were some services being provided in early childhood programs. We added that as some definitions, but we really clarified that that's an educational program for which information may be disclosed without parent consent to do that audit and evaluation function or that compliance determination. Certainly you could still get parent consent, probably not real feasible considering all the students or the parents that you have to get consent from. And frankly, we know some parents don't want to consent to that kind of data exchange. We don't want big government knowing what's going on. So that's why we have these exceptions to prior written consent to allow some of these necessary formats. Now, I think whenever you talk about disclosing PII from a student's education record without parent consent, you have some exposure, because what if something happens to that data and now the parent says, well, I didn't even consent to that information being shared in the first place. So we have some built-in parameters with the audit and evaluation. The information has to be protected. So even though you're getting without consent, you have to keep it secure and maintain some safety protocols, as Kala talked about. When that information is no longer needed for that audit and evaluation, you need to destroy it. So you can't hang on to the data indefinitely saying, well, 10 years from now, we may want to do a study that compared how the kids did 10 years ago to today. If it's not part of that original audit evaluation or ensuring the compliance, you can't do that. We also, and we don't really have time to go into this, but there are certain things about who's doing the audit and evaluation, whether it's staff from the state education authority and the protections they do, versus, let's say, the state contracts that out with an authorized representative who's going to act on their behalf. Then there might be some aspects where you need written requirements, written agreements to say, hey, you're getting this information to help us do an audit or evaluation of our programs. You can't just share that with whoever. You have to protect it. So you can do all this without parent consent. There's some inherent protections that you then need to do, but this is the mechanism. This is that magic. This is behind the magic dust that allows you to have these great data sharing agreements that Kyle is going to talk a little bit more about, and Sharon is going to discuss.
So I think what we're going to do next is we're going to try to bring this into some real life examples, because most of the people on this call right now are probably struggling with one or maybe even all four of these particular questions. So we're going to go one by one here. We got 4 scenarios. The first scenario, it's a really basic one. It's that fundamental question of who can be a parent.
All right, Frank, you want to hit the first one, and I'll look at the second one because that's more specific to IDA.
So when we used to do this question, we gave the parents' names of Jack and Diane. And every time I read this scenario, I have John Cougar Mellencamp going through my head, because I think of the way we originally worded this one. But we get a lot of questions, right? And I'm sure you get that too. Parents are divorced. Who has the rights under FERPA or IDA? We hear a lot about, well, who has physical custody of the child versus who has maybe sole legal authority or sole decision making. What we typically say under FERPA and IDA is, it doesn't matter if it's a custodial parent or a non-custodial parent. Parents have rights afforded under FERPA unless there's some kind of state law or document, a custody agreement that revokes one parent's rights under FERPA. If not, then you have to treat both parents as having full rights under those laws. I think with that, we talk a lot about authenticating identity and making sure that if it's a parent you've never heard of before shows up and says, hey, I am Ross's real father, I want access to his records under FERPA, you're going to have to do some due diligence to make sure that you're ensuring their identity, that this person is really Ross's parent. But that's kind of in the gist. Whether they're divorced, it's who has, unless there's something that takes away one parent's rights, both parents have have equal rights under FERPA, regardless of who has the custodial parent and who's non-custodial parent. I think, Kala, would you want to talk a little bit about the second bullet?
Yes, and I wanted to point out in what you just described, Frank, that IDA, treats them the same, Part B and Part C. In the example, they talk about having two kids, one with an IEP, one with an IFSP, and it doesn't matter. And it's not so much about taking away the parents' right, but as long as parents retain custody rights, unless one parent has sole legal custody or parental rights have been terminated, both parents, biological or adoptive, retain those rights. The scenario in bullet 2 is a little different. It's a child who's referred from a child welfare agency to the IDA program, and the child's in foster care and living with foster parents. The child's biological parents decline to consent, but they're not saying they won't consent. They just won't sign any consent forms. They're not available to sign forms. They're not objecting, but they're not signing anything. So can the foster parent serve as the parent under IDA? And the answer is, you can put it in the chat. I'd see if anybody's awake on a Friday afternoon, although it's a little earlier on the West Coast. We have people from all over the country. Thank you, Susan Kessler. I love you. You're awake. I know. Yes, go. Oh, now more people are awake. Excellent. Excellent. This is an easy question, right? That you do have the authority to treat that foster parent as the parent. And that is right, Mary. Now, if the biological parents specifically say no, and you have a conflict, IDA does contain that hierarchy of provisions where the biological parent is generally presumed to be a parent if there's a dispute. And that is where you might need to get the child welfare agency involved. And that is where the Uninterrupted Scholars Act amendments, USA, is very helpful, both under FERPA and IDA. We put out a joint letter guidance that the department issued saying the USA applies to IDA and to FERPA. And what that means is that if you have foster parents who've been serving as parents and there's a dispute, you can reach out to that child welfare agency. It's actually an explicit requirement under Part C that you do so that you can ensure that the foster parent and the information that the child welfare agency has about the ability of the parents to act on behalf of the child is available, and to also determine if you need to get a surrogate parent appointed under IDA. Thank you, Sharon Walsh, for adding that wonderful infant hearing word privacy link in the chat. At some point, I think somebody should put all the resources again at the end, because I've missed it in between all the other narratives. So that's it for who can be a parent. It's a quick and easy. You guys are all on the ball. Let's go to scenario 2, Ross.
Paula, real quick, just to
go ahead, Frank. Go to USA.
Sorry,
you guys have an ad?
Yeah, on the Uninterrupted Scholars Act, just to make sure, because USA, yes. It's only, as Kala said, pertains to kids who are in foster care. They're placed outside the home. It could be a group home, but where they're outside the parent's home. We've had some situations where when that was first passed, children and youth agencies are trying to use that as a mechanism to get on all kids that had some kind of relationship with the children and youth system, including those that were under maybe protective service or protective care. So just if you ever do any reading, and I think we may have a link at the end to the Uninterrupted Scholars Act guidance. It's very specific to students that are kids that are placed outside the home, not those in the home, but still under some kind of involvement with children and youth.
Thanks, Frank. It's great clarification.
Let's talk a little bit about sharing data with the referral source, shall we?
Sure. I mean, this is an area that's of constant angst for IDA programs, because for Part C, you've got physicians, EDI programs, other primary referral sources that want to know, hey, I referred this kid to you, what happened? Similarly, under 619, you may have Part C, which you have a special relationship, so you have a transition agreement, hopefully that deals with that, but you may have other referral sources that send you information and you're evaluating a child and you can't share that information back. So what can you do? What can you share back with the primary referral source? And is it different under Part B than under Part C? The answer is that it's not different under Part B or under Part C. But what did we say, basically? There are 3 avenues of sharing information. One is you have parent consent, right? So for Part C, there is that one piece where if the participating agency that entity, that umbrella of what you're using in your state lead agency to implement Part C, if that participating agency definition can include that primary referral source because they also provide services to that child ultimately. For example, like the EDI program may be actually doing more than just referring children. You might be able to share that information without parent consent if it falls under that definition of participating agency. That doesn't happen very often, but it can be the case. But if that's true, then that EDI program also has to comply with all of the privacy provisions for all their kids, which are their EDI kids, not just the Part C kids, because now they're in that bubble of participating agencies. So just be careful how you use that definition. And if you have any questions about that, reach out to your OSEP state contact or RTA providers like DaSy on this call. The other way is, of course, that you have parent consent to share that information back. And you can certainly ask the primary referral source clarification questions if you can't get through to the parent, like, hey, does this parent speak English? Is there a better way to reach the parent? Here's the contact information I have. And they might say, I have another phone number. I have a cell phone. You could try texting. Oh, by the way, this parent is primarily a Spanish speaker, or I have another email address, right? All that contact information you can get clarified, language of the child, language of the parent, because that all has to do with getting that child find information. But anything beyond that, if it's personally identifiable information, you're going to need parent consent, or if there's a specific exclusion that might apply. But typically the audit evaluation exception we discussed earlier would not apply in this context generally. So that's it. Pretty much it's parent consent or it's child find information. And the answer is the same under B and C.
Great. Well, thank you, Kala. So we're talking about referrals. Can we talk about a little bit about data sharing when the child transitions from, say, Part B or 619 or C to Part B or 619?
And can I do a quick time check, Frank? This
Yeah,
is
I feel like
Sharon.
we're zooming along. But
Yeah,
we're
we're
fast enough.
rapidly
You want to skip
closing
over this
in.
one?
Yeah, I'm wondering because I know there are some questions already in the chat, and we definitely want to save time for questions. So what do you think?
I think we should keep moving, but this one is really easy. You know, when I mentioned opt out earlier, I immediately got some responses in the chat. Thanks, Melissa from Nevada, for talking about the fact that yes, you can have a full-on parent consent requirement to share transition information, but that child find information has to be shared unless you have adopted an opt out policy. So let's go on to scenario 4.
So, scenario 4, how can we share data through written agreements under the evaluation exception?
And this is what we wanted to highlight, right? These are the 2 new resources that Sharon and I spoke about, that DaSy, ECTA, and NCHAM developed with the EDI programs. That's our bullet 1. And for bullets 2, really is about sort of this autism survey and surveillance exception that we use the audit evaluation exception. So I want to talk about this because Frank mentioned, what is this audit evaluation exception? It's really evaluation that we're using under IDEA. We're not using the audit for this purpose, the audit part of it. And the evaluation exception is based on this legal theory that you have the IDEA program, it's serving children with disabilities. And we have programs that also serve children with disabilities, maybe before or after, like EDI, or maybe the autism survey, or Part B, for example, or other programs, right? There may be other child-centered programs, childcare, healthcare programs. And they want to understand for the children served under IDEA, how are they doing? And can there be information that IDEA programs can get back around how children are doing later stages and earlier to be able to evaluate how quickly we're identifying children, what eligibility criteria they're eligible under IDEA Part C for versus, say, Part B, because Part B has different categories of eligibility. As you look at these different factors, the template we developed with CDC was developed jointly with specific states to identify what are the kinds of data that might be helpful and what are some of the outcomes and results down the road that might be helpful to share back that would evaluate the effectiveness. And not saying it's not effective as an IDEA program, but might help inform some of the services or choices that you're making in the IDEA program. This exception is not being used to track kids. It's not, I think one of the concerns I would have certainly as a parent of a child with a disability and having had a child with, a Cadillac of an IEP, is it's not intended to track children to say, hey, we want to know where this child is going to be because we think we can predict on some model, right, that if they're here in Part C and they're here in preschool, this is where they'll be by 3rd grade. That is not the intent. And we have learned that you cannot predict children's outcomes. It's amazing how the trajectory of a child's life can be dramatically changed. That slope just changes based on how earlier they could be identified. And we have seen research support this. So our purpose in looking at this evaluation exception and permitting the data sharing agreement, that is not magic dust, right? It's really to have the two agencies come together, determine what kind of data might be helpful. Legally, what can you share? And how does the IDEA program benefit? Because it's like a contract. There's got to be a quid pro quo, if you've heard that word, or legal consideration, if you've heard that term, if you're a lawyer. It's that, what is the IDEA program getting? It can't just be a one-way street. So when CDC came to us and say, we want this data, it was like, that's great, but what are we getting out of it? Like, seriously, what are my programs, my IDEA programs? They were like, what do you mean? Why do you want to get anything? I'm like, well, you can't have this data unless we get something out of it. They're like, really? I said, yes, there's a thing called an auditable exception. They said, oh, tell us more. And so we started to talk to their lawyers and we came up with the theory of it. But in practice, I couldn't dictate to a state, hey, what is helpful to you? Each state and program had to look at it individually. Is this a mandate by the Department of Education at the federal level? It is not. It is an option available to you, but the states we have seen, and go to that web link because the CDC came over to us and thanked us. I met with Assistant Secretary Glenna Gallo, and they did a great presentation to our OSERS and OSEP staff, at which they were thanking us to say, look at the prevalence rate data. It's based now on this broader group of data we were able to collect when we were only collecting this much, and we have more accurate information, and our numbers are changing. And the dozen or so states that we're working with that had come out and reached out to us here at the Department of Education and OSEP, it was a dramatic difference. We have an interagency autism group at the federal level. We were amazed by these results. This information was shared at the state level, but it was aggregated up at the national level so we could start to look at, what does this look like? How does this inform policy decision-making and program eval? So on that note, I'm going to stop to describe scenario 4. If you can go to the next slide, it might just be more snapshots. Oh, it's relevant resources. So I don't know where the CDC thing one is. It might be on the next slide.
Yeah, so
I don't know. Oh, there's the 2 resources again. But the same thing with the EDI program. You have to sit down with the programs. So I know, Sharon, if you wanted to add a bit about how your experience was, we had to get buy-in. I'll tell you, a few of the states that called me, they're like, we are not doing this. It's okay. But let me explain to you. Let's walk through, what would you get out of it? And ultimately, the 2 of the states that were really the least willing to do this actually ended up finding things that they could find useful. I won't say which 2 states there are. They might be on this call today. But more importantly, they found data that they could use to make actionable in program improvement, which is the purpose of the evaluation exception. So we
I would
wanted
totally
to highlight
echo.
this.
Yeah, I
Okay,
would
go
totally
Sharon.
echo what you just said, Carla. Sometimes one program comes to us or the other, and we always say we need both programs. Sometimes they come together and say, we're ready to do this and we need help. But that what you stressed about the value to both programs and improving their own programs is critical. There's a couple of really good questions in the chat. Do you think it would be okay if we took down the slides, and with our remaining 7 minutes or so, would you all, if we turned off the recording, be willing to entertain a couple of those questions? And they're all toward the end, but above those links.
Well, if you could ask them, that would make it so much
Yes,
easier.
okay, here we go. We could leave the chat another minute, Rachel, or 2, in case people throw things in. Doesn't look like they are, but got lots of thank yous in the chat though.
And I'm giving you a,
Hi, Evelyn.
yeah,
Thank
hi, it was a
you.
great presentation, really
Yeah,
was.
it was really good. I can't wait to talk to folks who were here because I know they appreciated it. You guys were terrific. Thank you so much. And I'm sorry we had to rush toward the end there.
I
But-
know we hadn't timed this out. I think if this hadn't been our first one,